We want to welcome everyone to our webinar on Tumultuous Markets Part 2, Mitigating Risk in International Energy, Construction, and Private Equity. We hope everyone and their families are well and continue to do so. This is an extraordinary time, to be sure. My name is Steve Davis, an energy partner in the Akin Houston office. Earlier in my career, I lived in the Netherlands, worked as an engineer in Abu Dhabi and Bahrain, and practiced law for 6.5 years from a Singapore base. This presentation follows on from our April 21 webinar that focused on the U.S. side of the energy issues in the aftermath of U.S. oil prices briefly turning negative and the greater circulation of the coronavirus. In the discussion today, we'll be looking at the wider international position in energy, construction, and private equity, and updating on the price and storage issues we talked about 2 weeks ago. As I said, this is really an extraordinary time, a confluence of events unlike other times. Yes, we've seen other oil price wars, including between Saudi and Russia, but now we have over a decade of growing shale oil and shale gas production in the United States and a build-out of LNG liquefaction and receiving terminal capacities around the world, all in anticipation of growing demand for energy products, particularly in the developing world. And then this dramatic sudden demand destruction caused by COVID-19. So let's explore these issues and the legal ramifications. First, let me introduce my partners with whom I'm delighted to have the privilege of practicing law. First, Michael Joyce is an energy partner based in our Singapore office whose practice focuses on international cross-border M&A and international projects with particular emphasis on the oil and gas, LNG, mining, power, renewables, and infrastructure sectors. He's a senior person in the energy practice in Asia for us. Second, Hamish Lau is an international construction arbitration partner based in our London office who represents clients in a range of high-value, highly technical international construction and engineering disputes and arbitrations, and is ranked Band 1 in both construction and international construction arbitration in Chambers and Partners UK, and in the top tier in the UK Legal 500. Next, Sean Lascelles is a corporate partner based in our London office who has more than 20 years of experience advising on cross-border M&A and private equity transactions. Sean has deep knowledge of the oil and gas and energy sectors, often across emerging market jurisdictions that frequently includes Africa and Russia. Next, Julia Nicol is an energy partner in our London office who has advised on developing, financing, acquiring, and disposing of power projects for over 20 years across the UK, Europe, Africa, and the Middle East. And he works on many matters in addition to power. Next, one of my Houston-based partners is Gabe Procaccini, who advises on major energy transactions with a special emphasis on midstream activities and transactions involving crude oil and liquefied natural gas. Clients include major U.S. international producers, midstream companies, international conglomerates, independent commodity trading houses, LNG project developers, and on and on. And lastly, Justin Williams is a litigation international arbitration partner based in our London office. In fact, he heads that practice for us. He has acted in complex, high-value international arbitrations under all the major arbitral rules and in centers of arbitration all over the world, with wide-ranging experience in complex, high-value, cross-border litigation and energy disputes, and with whom I've had the privilege of working on numerous matters. So those are the introductions. So now let's jump into some questions. Michael, let's start with you. What are you seeing in terms of international demand impacts in the oil, gas, and LNG space?
Thanks, Steve, and hello, everyone. Steve, the U.S. situation described in the 21 April webinar mirrors what we're seeing internationally in the upstream oil and gas sectors and in the LNG sector. The impacts basically fall into three categories. First, collapse in demand. Second, stress on supply chains and in particular storage capacity. And thirdly, corporate and government financial stress due to the first two issues. In terms of demand, we've seen sharp demand falls globally due to COVID-19 related drops in manufacturing, industrial production, and transportation. For example, consumption of jet fuel globally has fallen by around 75%. To quote a few other statistics, In terms of Asia, Chinese oil demand in March was down around 3 million barrels per day, or equivalent to 20% of total consumption. In Japan, March crude imports fell 10.2%, and in the same month, consumption in India fell by 18%. Similar falls are happening in the rest of Asia and likewise in Europe, with lockdowns in Italy, Spain, Germany, France, and the UK. And of course, this is coming at a time when, as Steve has mentioned, we have substantial oversupply in oil and gas markets. Because of the collapse in demand, the impacts are then felt through the balance of the supply chain. And so next, the refining sector has been hit hard. For example, in China, although it has recovered slightly just recently, utilization rates for Chinese government-controlled refiners are down to around 30% in March, and for non-government-controlled refiners, around 50%. Reductions also occurred in India, where refinery throughput is down around 15%, South Korea by around 20%, and Japan is also down and has brought forward maintenance of facilities equivalent to around 15% of total refining capacity. We've then also seen pressure to close refineries, and indeed, we have seen some closures globally. So, with consumers not consuming and refiners scaling back operations, producers have nowhere to sell their production, and so storage capacity is rapidly disappearing. And as we saw recently in the US, with nowhere to sell production and nowhere to store it, prices go into free fall, and we even saw negative pricing in the US. A similar story is being played out in the LNG sector, with the collapse of demand causing storage tanks to reach capacity and spot prices to plummet. The severe demand shortage and price impacts have obviously also meant severe damage to oil producer and refiner revenues and on government budgets reliant on oil and gas royalties. Additionally, we've also started to see bankruptcies, impairments, and plunging corporate profit forecasts. All this at a time when, even before COVID-19, the global energy sector was suffering. Trying to mitigate risks in this environment has become extremely difficult, if not impossible, particularly where take-or-pay contracts are concerned. Parties have been trying to look at alternative markets and for alternative storage and refining destinations such as Europe. However, reductions in refining capacity and LNG storage capacity is truly a global phenomenon, and so safe havens haven't been found. Given that background and the absence of other contract relief or cooperation between parties to weather the storm, FM is often the only other resort for buyers and sellers, and reliance on FM and other contract remedies is what we're seeing. Steve, since Gabe and I will deal with some of the FM and related contractual issues in the oil and gas and LNG sectors later in the presentation, I think I'll leave it there for now.
Thank you very much, Michael. These are very difficult times for many people and for many companies, and we very much recognize that. So, Gabe, let's turn to you. A couple of weeks ago, we spoke about U.S. oil storage constraints. How is that playing out now, both in the U.S. and elsewhere?
Thanks, Steve, and good to be with everyone. Unfortunately, the oil storage situation is not improving as quickly as many had hoped. According to Rystad Energy, nearly 90% of global oil storage is full, with the remaining 10% of available capacity expected to be fully utilized in the next 2 to 3 weeks. In fact, oil storage in South Korea is now reportedly already fully booked, while Bloomberg indicates that storage capacity in India, the world's third largest importer of crude oil, is nearly full, with more than 1 billion people under lockdown in that country. In Cushing, the primary delivery hub in the United States for WTI crude, is already more than 80% full. Meanwhile, the U.S. Strategic Petroleum Reserve is receiving crude deliveries from U.S. producers, but only about 23 million barrels of space remains available, roughly 2 days of U.S. production. In addition, marine trackers are reporting some of the highest levels of oil tanker activity in history as oil gets stored at sea. And as the world runs out of traditional oil storage space, traders and crude buyers are turning to alternative storage facilities, such as rail cars and even underground caverns. And the storage situation is raising safety and environmental concerns. At a recent hearing in Texas on forced production cuts, at least one major storage operator warned that operating storage tanks at max capacity for extended periods, coupled with potential shortages of well-trained on-site personnel due to COVID-19 outbreaks, significantly increases the risk of a major safety incident. And in the U.S., with record numbers of supertankers holding millions of barrels of oil in sensitive offshore waters, the Coast Guard has increased surveillance due to pollution concerns. In response to the cataclysmic storage situation, global oil prices continue to trade near historic lows. Many predict we are once again only days away from seeing extreme volatility in prices, and a spate of panic selling by those participants without access to sufficient storage facilities. However, this time it may not just be WTI that trades deep into negative territory. The Intercontinental Exchange confirmed it is preparing for negative Brent pricing in its contracts, and we're seeing increasing margin requirements across the space. And if the U.S. bans the import of Saudi crude in response to the Saudis' role in the oil price war, many expect the price of Middle Eastern crude grades to crash too. And while some producers have slowed drilling activity in response, and of course OPEC agreed to reduce supply among its member states by nearly 20% as part of a record-breaking deal recently, many analysts believe more production will need to come offline for the market to rebalance, particularly if it becomes clear in the months ahead that we have some form of permanent demand destruction, as greater numbers of workers elect to permanently work from home and developing world governments spend ever-increasing amounts on entitlements, further encouraging people to stay at home. But further production cuts to address storage without more aggressive action may be a challenge. Many oil producers have take-or-pay obligations and need to produce or pay, and so fully shutting in is not always an option. Shutting in can also cause irreversible damage to some reservoirs, which would make a bad situation for some producers even worse. That said, despite all of the bad news, there has been a sliver of good news in the market recently. In its most recent reports, the American Petroleum Institute has reported a decline in motor gasoline inventories. Analysts have been expecting a continuing build in inventory. And according to real-time traffic data, over the last week, we have finally started to see an uptick in automobile traffic in some of the major U.S. metro areas. So perhaps U.S. demand has already reached rock bottom, and as the global lockdown measures continue to ease, we can narrowly escape an oil storage Armageddon. Over to you, Steve.
Thanks, Gabe. It is indeed a very complicated situation with all kinds of interactions going on, so it's very difficult to see what the future is going to look like here. Julian, let's turn to you and to a little bit about the power side. We've seen some supply chain and workforce issues affecting renewables projects. How is COVID-19 affecting what you're seeing in renewables internationally?
Well, thank you, Steve, and hi, everyone. So maybe looking at some general trends to kick off with. I mean, power demand has decreased during lockdown in the industrial and commercial sector, but it looks like fossil fuel plants so far are taking the curtailment hit rather than renewable energy plants. But that decrease in power demand has caused a nosedive in the wholesale electricity price, certainly in the markets that we cover. And that sort of price nosedive, if you like, has really caused a lot of nervousness in corporate PPA pricing discussions. It's opened up a gap between what are termed subsidy-free renewable energy projects and those government-supported renewable energy projects currently under development. So subsidy-free renewables projects are basically stuck in the mud as far as we can see. They're progressing very, very slowly, if at all, whereas government-supported renewable energy projects are moving ahead, and some moving ahead at pace. But the biggest issue that we're seeing, Steve, really on the legal side is how to manage force majeure claims that are made within the chain in either operating projects or those renewable projects under development. We'll come back to that in a minute or two, but maybe just looking at development stage renewable projects at the moment. So government-supported projects, as I say, governments are taking measures to enable those projects to continue in development. A good example of that in the UK is the Feed-in Tariff Amendment Coronavirus Order 2020 that was passed on the 31st of March, and that extends accreditation deadlines for affected projects by up to 24 months. In Europe, another example of governments facilitating development stage renewable projects is with respect to solar tenders. We're seeing countries carve up solar tenders into different timeframes. So France, for example, has carved up its next round of solar tenders such that a third of planned capacity will be tendered in July and 2/3 will be tendered in November. Now, if we look at development stage subsidy-free projects, as we said, corporate PPA discussions seem to have ground to a halt. parties are very nervous about price and volume risk and are therefore just not committing to those negotiations or discussions at the moment. In general, the key unknowns for parties are, what the current environment will do to limited recourse debt pricing and the pricing of hedging moving forwards, and what effect will the current environment have on corporate PPA activity, once we emerge, from this. Now, if we move to construction stage projects, some of the projects that we're involved with have encountered difficulties in construction. There's confusion around site operating procedures across various countries. That seems to be sort of clarified as time goes on. But from what we can see, utility scale solar PV projects in particular with a local workforce appear to be okay. They are continuing. Smaller projects where social distancing on site is not possible seem to have stopped. There have been instances of delays in obtaining key permits from government departments, but governments are trying to sort of deal with their staffing shortages by having expedited permitting procedures for smaller renewables projects. They're kind of waving them through with the specter, though, of normal permitting requirements reapplying to those projects later on, so sort of retrospective applications for permits when the situation normalizes. We're also seeing time extensions being granted by governments for project developers to meet commissioning deadlines. Germany have been at the forefront of this, certainly within the European geographies, so that the developers won't suffer financial penalties for late connections or late commissioning. Supply chain disruptions have been an issue and have been a source of change orders and force majeure claims. Hamish will talk about that in more detail. But China resuming production of renewables kits should help with that. And then I think in the emerging markets projects that we're involved with, local currency depreciation against the US dollar has been an issue, particularly for those projects procuring kits in US dollars without adequate foreign exchange hedging. Obviously, that's less of an issue in Europe. So finally, turning to operating stage projects, PV plants and most solar plants generally operate unmanned or with a skeletal staffing level. But the issue with operating renewables plants that's really been on our desk has been off-takers not performing their obligations under power purchase agreements and seeking to invoke force majeure. And Justin's going to talk about force majeure later on. But those force majeure claims, they've given rise to very complex discussions. Off-takers having a skeletal staff, meters can't be read as envisaged in the PPA very often. There is the decrease in power demand generally as a backdrop is an issue. End consumers not paying their bills and also not being cut off even though they're not paying their bills. If, as a project, you have recourse to a government guarantee, should you claim under that guarantee? It's a very complex commercial judgment in terms of balancing your relationships in country with governments and your off-taker versus actually complying with your covenants and financing documents to enforce all of your rights under project documents. So difficult discussions. But what we would say is that those discussions have tended to be constructive and sort of friendly to date. There is this sense of we're in it together. There are discussions around off-takers deferring payments or part-paying invoices until their cash flows normalize, and then a discussion around ensuring that if the off-taker can only part-pay an invoice, that actually the economic effects of the power purchase agreement are maintained over the life of the PPA. So, Steve, I'll leave it there and hand back to you, if I may.
Thank you, Julian. Very comprehensive. One of the things I find so interesting are the number of governmental reactions that we're getting from regulatory relaxation, I guess, that you talked about, and so much stimulus coming into it. I know our public law and policy team has been working night and day over the last couple of months, trying to address all of those kinds of things. So let's turn at this stage where we're looking at the bigger picture. Sean, let's turn to you and see what you're seeing in the energy-focused private equity world.
Thanks, Stephen. Hello, everyone. So on top of all the same issues and challenges suffered by everyone else in the energy space, private equity also has its own unique challenges in an environment like this. I'm going to touch on a few of these now. What we've seen across the board in the sector is an immediate dedication of resources away from the deal making and exit preparation to assisting and supporting portfolio companies, with a focus not only on those that are likely to be the hardest hit, but also on those with the potential to hardest hit the overall performance of the portfolio. At the portfolio company level, aside from the immediate operational needs of health and safety and supply chain issues, the key focus, given the leverage in many of these PE structures, has been in ensuring short-term liquidity. And this has been addressed in a number of ways. Firstly, companies have been drawing down on their existing facilities, reviewing options for further financing, whether that's from the banks or potentially through further drawdowns from limited partners, reviewing credit facilities for potential breaches and vulnerabilities going forward, and anticipating any need for bank consents. Secondly, we've seen a significant interest in government support measures across the various jurisdictions. We've not seen many of these specifically targeted at the energy space, but generally speaking, these are available to PE portfolio companies, the same as to anyone else. I don't propose to go into those in any sort of detail here, but just wanted to mention the three most common measures that we've seen PE companies taking advantage of. Firstly, tax deferrals. These have been offered in almost all European jurisdictions, have proved easy to take advantage of, and have had immediate and often significant impact, and we've seen many portfolio companies taking advantage of these. Secondly, we've had the various workforce and employee measures, with governments effectively picking up a percentage of employee salaries where they've been put on leave or furloughed. Again, many companies have been taking advantage of these, but I think there's a distinction here, PE companies. Firstly, in many PE portfolio companies, and specifically in the energy sector, there isn't always the overcapacity that you see in other sectors. So the capacity for furloughing is more limited. Secondly, I think PE houses are very wary of the potential backlash for calling on government assistance to lay off staff. There's certainly been some sitting on the sidelines here. Finally, government loans and guarantees. Again, nothing energy specific, but these have been widely offered by European governments, and with some exceptions are generally available to PE-held companies. Uptake of these, however, has been slower and more difficult than other measures, and I think this is an area we'll see more activity in the coming months. One point I think worth specifically noting in a PE context here is that there is still some concern, and certainly in the UK, that taking advantage of government loans may come with strings attached. So again, we're seeing some companies holding back here for the moment. I'll let someone else speak now, but later on we'll be talking about the shift from this first phase, where the focus has been very much on immediate actions to be taken in the portfolio company, to a consideration of some of the broader issues facing PE houses as time moves on through the crisis. Thanks, Steve.
Sean, thank you. That's a very good overview there, and certainly there may be some strings attached if you want to take money from the government, but sometimes there aren't very many options available otherwise. I wanted to just let all of the listeners know that you can submit questions through the link that you had there. So please do so. We'll be gathering them up and answering them at the end. Earlier, we heard several different mentions about force majeure. I can't imagine in this context that we would actually be talking about force majeure. But let's dive into it a little bit more deeply. And Justin, let's start with you. And at a high level, tell us what is force majeure, and also what about material adverse change? When are they available in response to issues raised by the pandemic and by all this oil price volatility? What practical issues should be considered?
Thanks, Steve. So the bottom line is that under English and New York law, both force majeure FM and material adverse change MAC clauses, they're creatures of contract, and whether relief is available depends on what the contract says and whether the facts satisfy the particular contractual criteria. And as Michael and Julian said earlier, what we're seeing at the moment really is principally claims to FM. And at a high level, there are usually three criteria that need to be satisfied to make out FM. So there needs to be an event that's not reasonably within the control of a party. Number two, that could not have been prevented or mitigated. And number three, has hindered or prevented or delayed some aspect of performance. Sometimes you get a list of events that may be force majeure, and sometimes that includes things like pandemics. But usually that list is not determinative, i.e., so you've still got to actually satisfy the three criteria I mentioned. Sometimes also, in particular in things like LNG sale and purchase agreements, you also might have a list of events that cannot be FM, things like changes in markets or changes in demand. But if you satisfy the criteria for FM, the critical point then is to notify, to look at your contract, really look at what the notice requirements are, and to comply with those requirements. And only when you've done that, and if there is an FM event, only when you satisfy those things, typically then, will you get relief. And usually it's going to be suspension of performance of the contract. If the FM event continues for a period of time, some contracts specify termination, but typically the relief is suspension. And again, it's only for so long as the FM criteria remain satisfied. And again, the really important point to bear in mind is that if you get it wrong, if you claim FM and suspend performance but do so wrongly, not in compliance with the contract, then you risk being in breach. You might even risk the contract being terminated, and of course, all of the liability and damages that might flow from that. So you need to get it right. And I think I'd highlight four key practical points on this. So number one, keep records of how current situation, COVID-19 and so on, are affecting your ability to perform. Number two, carefully consider what steps can be taken to mitigate the effects and record the steps that are being taken to mitigate. Number three, ensure that the business understands what its contractual rights and obligations are and the consequences of getting it wrong. And number four, consider a dialogue with your counterparty about managing performance during the current situation. As was said earlier, actually, many times at the moment, there's a good deal of cooperation, but there needs to be a dialogue before that starts. For MAC, or Material Adverse Events clauses, the key point is that it's the other way around from FM. So for MAC, this provides relief to the party that is not affected by the external event. So like in M&A deals, they may allow the buyer to pull out if stated events occur before closing that are detrimental to the target. In finance agreements, a MAC clause may allow the lender to draw stop or to call an event of default. But the bottom line is that MAC clauses are actually rarely invoked, not least because it's usually a pretty high bar to satisfy. Often there needs to be a change that's more than merely temporary, which begs the question, well, what is temporary? And also it needs to be a change or the potential for a change that was not foreseen at the time of the contract. And again, those are typically present quite a high bar to satisfy. There have been instances we've seen, so it was reported recently that a buyer of the UK retailer Moss Bros has sought to argue MAC, but it's going to be a pretty rare instance, I think, where parties will actually invoke MAC clauses. Back to you, Steve.
Thank you, Justin, very much. A great overview of how what the law looks like on force majeure and how people should be looking at it. Let's apply it a little bit more specifically here. And Michael, we'll turn to you and ask how you're seeing force majeure affecting long-term buyers of LNG, and what are some of the hurdles they face in claiming FM, and are there alternatives?
Thanks, Steve. Look, in terms of the impacts that we're seeing from an FM perspective on long-term sale and purchase agreements, we are hearing from industry participants and contacts that FM is certainly being used by buyers to seek relief from delivery and take-or-pay obligations. Some examples that are out in the public domain that I can talk about are, for example, reports that Chinese national oil companies have claimed force majeure against a number of international oil companies, that GSPC, GAIL, and Petronet of India have issued force force majeure notices following the Indian government's lockdown, which took effect on 25 March, and that South Korea's KOGAS has approached key suppliers to request a delay in its May to October deliveries. Some industry participants and contacts are also suggesting that importers in Japan will probably follow suit. Because force majeure, as Justin has mentioned, are not standard form clauses, however, a successful claim for temporary relief against performance obligations due to FM will always turn on the precise terms of the relevant clause. One thing is relatively clear, though, and that is that changes in market conditions, such as a collapse in downstream demand, will not normally be enough to trigger a successful claim for FM relief against delivery or take-or-pay obligations, as a number of the current claims may well derive from demand concerns rather than from much clearer grounds, for example, the physical inability to access a port or receiving terminal due to a government-mandated closure. It's quite possible that buyers may face some difficulties in making out a claim for FM relief. Likewise, as long-term LNG contracts normally contain a requirement for the buyer to have sufficient storage capacity to receive cargoes, calling FM for inability to take due to storage constraints arising from failure of demand may similarly meet with difficulty. Obtaining FM relief can also depend somewhat on whether the delivery is on an FOB or a DES or DAP basis. Under DES contracts, where the seller has the responsibility to deliver to the buyer's unloading port, issues affecting the buyer's port or facilities may more easily lend themselves to an argument for FM than in an FOB context, where the buyer is usually retaining maximum flexibility to divert or resell the cargo after loading. Also, if FM is actually successfully claimed, it also has to be remembered that prolonged FM also gives rise often to a right to terminate. Accordingly, the need for relief needs to be balanced against the possibility of termination. And when we're talking about long-term LNG sale and purchase agreements, the primary reason for entering into these was long-term supply certainty, so this is no small consideration. Given some of the difficulties claiming FM, buyers also need to look at other contractual rights. For example, buyers can potentially look to exercise downward quantity tolerance rights to reduce the overall volume that needs to be taken in a contract year. It may also be possible to renegotiate annual or quarterly delivery programs or exercise cargo cancellation rights. Clearly, the terms of the relevant clause will determine whether these rights are available, and in particular, the negotiation and notice period requirements are crucial, but these clauses should be closely scrutinized. Change in law clauses could also potentially provide relief. These clauses normally provide relief where there has been a change in law which impacts, for example, the cost of performance, and unlike force majeure, do not rely on prevention or delay in the performance of a contract obligation, but rather respond to an increase in costs flowing from the change in law. Price review clauses should also be looked at closely. These were being considered, I have to say, by many buyers even prior to COVID-19 due to falling prices, but the incentive to do so now has only increased. Now, while admittedly this last option does not assist with the requirement to take quantities today or the price associated with them, it may assist with recouping some of today's costs by building in lower prices for future cargoes. Thanks, Steve. I'll leave it there.
Very good, Michael. Thank you very much. A good overview of how these complicated documents work, and do appreciate that. Gabe, let's apply some of this in the U.S. midstream context. How is FM affecting those businesses, including long-term supply contracts and the kinds of exports we're seeing out of the U.S.?
Thanks, Steve. Force majeure, the threat of force majeure, is certainly impacting the U.S. midstream and export industry as participants explore all possible remedies to mitigate risk in this difficult operating environment. We're seeing FM declarations already in the midstream space. For example, Tidewater Midstream recently reported that Husky Energy has delivered a force majeure notice under its offtake agreements from the Prince George refinery. So today I'm often asked whether force majeure can help relieve a party of its midstream obligations, and in particular, whether general FM declarations can provide relief. For example, if a governmental agency, such as an oil and gas regulator, issues an FM notice, or President Trump declares the coronavirus an act of God, as was recently requested by Oklahoma's governor, will the midstream operator be relieved of its obligations? The short answer is we can't say for sure without a review of the applicable FM provision, because as Michael indicated, the answer really does turn on the language in the contract. But generally, such declarations alone will in almost all cases not be sufficient to give rise to a valid force majeure claim under most midstream agreements. So when confronted by an FM declaration or threat thereof in a midstream contract, the first line of inquiry should be to analyze the specific event that has been claimed as giving rise to the request for relief. While a force majeure claim could potentially be asserted on the basis of the occurrence of COVID-19, on the basis of governmental restraints related to COVID-19, what I'm more frequently seeing companies consider in this current market environment are potential force majeure claims due to storage constraints. So I'll focus on that issue. As previously stated, force majeure affords relief from liability to the extent a party is prevented from performing, and thus in order to declare force majeure due to lack of downstream storage, unless otherwise agreed by the parties in the force majeure clause, entities generally must have an obligation under their agreement which can no longer be performed due to storage limitations, such as a storage obligation. So then the question turns to whether the parties have such obligations. Many midstream and FOB LNG sales agreements do not include a storage component or other related obligations. For example, those agreements might provide that a seller has an obligation to deliver a minimum quantity of oil or LNG, and the buyer has an obligation to take or pay for those products, but neither party necessarily has an obligation to store. And that's often an important distinction for force majeure analysis purposes in these cases. Thus, if there's no specific obligation affected in the underlying agreement, and lack of storage, for example, is not preventing the parties from performing the activities contemplated under their agreements, buying and selling crude oil under a long-term supply agreement or LNG under an FOB LNG SPA, then force majeure is likely not going to be available just because downstream storage is full or nearly full, no matter how inconvenient that lack of storage might be. The fact would remain that parties can still perform the activities contemplated within their agreement. In addition, as Michael mentioned in the LNG context, market conditions such as lack of markets or lack of demand or changes in commodity prices are often excluded from the list of circumstances that could give rise to a valid force majeure claim. And that's certainly true in the U.S. midstream context. So for parties attempting to declare force majeure due to lack of storage or even COVID-19, but the claim is really due to the lack of a market, a midstream counterparty might well look through the claim and argue that the request for relief is really attributable to market conditions, and thus the claim should be dismissed. Back to you, Steve.
Thank you very much, Gabe. One of the key things I think we're hearing is this to the extent. I often tell clients those are kind of magic words in the legal industry. So to the extent you're adversely affected and you otherwise meet the requirements, then you get it. But to the extent that you're not affected, you still have to perform. Hamish, your name has come up several times earlier, so now let's turn to you and see what particular issues force majeure is causing in the construction space. And if force majeure isn't available, how can the impact of the current crisis be mitigated?
Sure. Thanks, Steve. Well, typically force majeure is available. The problem with force majeure, however, is that it typically only gives a contractor an extension of time. And so contractors will look for other parts of the contract or statute to try and get time and money. And I guess there are 3 or 4 areas. One is an orthodox loss and expense claim caused perhaps by, as Julian mentioned earlier, a change in working methods due to social distancing or perhaps additional medical testing in or out of the site. Second, orthodox delay claims. The event of force majeure or COVID-19 has caused delay to some critical activities. But we do have to be careful here, Steve, because certainly under English law and common law jurisdictions, there is a big debate that the COVID-19 must be the operative cause of the delay. If it is concurrent with other causes, then relief is not automatic. And then the third big area, I think Michael touched on it earlier, is adjustments or changes in legislation. Now, this, I think, is going to be a growth area because contractors will look at, for example, FIDIC clause 13.7 and say that various statutes, regulations impacted long lead items, have impacted working methods, health and safety, you name it, a whole plethora of issues. And these clauses are lucrative. They do allow a party to adjust the contract price. But not only price, they also give rise to an extension of time. So, short point, from a contractor's perspective, it's not just force majeure, it'll be other time and money claims. From an owner's perspective, projects late, LDs, liquidated damages for delay to completion, and you then get into the commercials of whether there ought to be a dispute or simply a recalibration in terms of changing time and money consensually. Then I would expect to see a number of EPC contracts being amended and restated. One other thing, Steve, you mentioned earlier, government reactions to COVID-19. With the exception of Singapore, which has brought in a COVID-19 Temporary Measures Act 2020, no other country has really reacted in terms of construction. The Singapore legislation is very good. It effectively places a 6-month moratorium, so it prevents owners cash and bonds or appointing receivers, and perhaps most importantly, stops either party, contractor or owner, from commencing any litigation or arbitration. Let me stop there, Steve, and take questions as and when they arise later on.
Great, Hamish. Thank you very much. These are, again, very good points that people need to be considering, both owners and contractors. Sean, let's turn back to the private equity side for just a couple of minutes. And Justin earlier mentioned material adverse change, MAC clauses. How are they impacting the private equity world?
Sure, thanks. Well, again, at the portfolio company level, PE houses and their management been looking at MAC and FM clauses in exactly the same way as everyone else. So there's no real distinction there. At the PE house level, MACs, they don't really feature in the LP agreements or directly affect drawdowns from LPs. But where they are potentially most relevant is in the context of transactions that have been entered into but not yet completed. But although MAC might in theory enable a party to get out of a transaction, we've not seen these as a common feature in the European context for a number of reasons. Firstly, I think in recent years, MACs have generally become less common, partly driven by PE's use of the lockbox mechanism. Secondly, where they are included, they've tended to be more business specific and they've become narrower and narrower. So we're typically seeing things like changes to oil prices and macro events such as a pandemic carved out anyway. And then thirdly, as Justin said earlier, even if you do have one, enforcing them and demonstrating the necessary material detriment can be a very high hurdle.
Yeah, yep, I agree with all of that, Sean. Let's stick with you for a minute and just let you tell us about things about what PE investors and portfolio companies should be doing from a planning perspective at this point, and what are the broader implications of the downturn on PE divestiture decisions.
Well, as I mentioned earlier, with the immediate needs of many portfolio companies now assessed and to varying degrees being dealt with, I think PE houses are now moving into a new phase and planning in a number of areas. Firstly, back at the portfolio company level, having hopefully solved or put off or put a band-aid on the immediate liquidity issues, they're looking at longer-term stabilization of the portfolio companies, including getting the workforces safely back to work, getting the businesses back up and running, and finding the new normal. Specifically as part of that, I think they'll continue to review and assess those governmental support measures that I talked about earlier. And even where, as now and as I said, there is some reticence to take advantage of those, I think given the uncertainty on the path back to normality, it would be prudent, and we're seeing PE houses taking the necessary steps now to ensure that if that support is needed, then the portfolio company has satisfied all the eligibility requirements to seeking access to that support. At the PE house level, the timing and strategy for exits across the portfolios now being completely reviewed. IPOs have been pulled, routes to exit that previously existed no longer exist, valuations that had driven earlier exit decisions have fundamentally changed and had differing impacts on different companies within the portfolio, and many of the assumptions have been trashed. But pressure to return funds to investors and to demonstrate strong returns still remain. So while it's impossible really to predict how divestitures are going to pan out, I think we can certainly expect some lengthening of the holding periods. But fingers crossed, and hopefully similar to the last economic crisis, the impact on those holding periods will not be as bad, as some commentators fear. Finally, and hopefully, I think we'll see an increased focus as resources are freed up from those initial sort of immediate reactions to the crisis. We'll hopefully see an increased focus on new opportunities. Clearly, there are still very strong, very significant challenges to deal making in the near future, continuing global uncertainty, debt and capital markets, which are currently frozen, valuations all over the place, investor pressure and unrealistic seller expectations. But with the huge amounts of dry powder that we're all aware of, and a willingness, for PE houses these days to explore alternative types of investment, hopefully we're going to see deal activity begin to come back as PE houses explore the broad range of opportunities to come in now at a low entry price.
Very good, Sean. Thank you very much. I think these comments about the flexibility that a lot of PE funds have, and other companies as well, are looking to the future. So we have very difficult times now, but of course that also translates to opportunities for folks who have that dry powder. So let's turn now to some key takeaways, and let our team here run through some of those. Julian, let's go back to you. What are some of the key takeaways from a renewables perspective?
Thank you, Steve. So key takeaways I would suggest could be get ahead of critical issues before they arise. And by that, I mean make sure that you and your team are, and really the team running the plant, are familiar with, on top of, representations, covenants, information reporting requirements, and events of default in the project financing documents that relate to the plant. If the plant is debt financed, make sure you keep your lenders fully informed of what you're doing regarding any force majeure claims, MAC, any events of default, or potential events of default. Lenders don't like being left in the dark. Ensure that if you're not pursuing a right under a particular project document, for example, the right to make a claim under a government guarantee, and you may not be doing that for all sorts of good reasons, you're pursuing claims under other documents first, just make sure that you're not doing anything that could be constituted as a waiver of that right to make a claim under the government guarantee. Finally, I would say, just when considering all the options at your fingertips, if you are the recipient of a force majeure notice, one that you may not agree with, and that's often the case, I think, with a lot of project companies currently in the market receiving FM notices from off-takers, just make sure that you're carefully balancing the way that you approach it, the rights you may have under your project contracts with, maintaining strong relationships in country with the off-taker and with the relevant government. So, Steve, that would be it from my side.
Thank you, Julian. I think those are very good comments. We've heard several times here about the importance of communicating with your counterparties, with your lenders, with the government, communicating. So you might have rights, but maybe you don't want to exercise them, at least not to the full extent that you could. Hamish, what can you add from a construction perspective?
Sure. Thanks, Steve. I guess it's maybe three takeaways. if you want to make a claim under force majeure, make sure that there is a clear and direct link between COVID-19 and the loss, whether it's time or money, that is being sought to be recovered. Second, keep in mind that there are subtle differences between common law and civil codes, and these will be relevant, especially in the context of the application of, say, good faith when one exercises rights and obligations. And the third, and I guess the obvious point, is please read these long, detailed contracts very carefully, because in these clauses there is a lot of opportunity for time and money claims to be made. How's that?
Hamish, great. Thank you very much. Hamish, those are, I think, very good comments. We, again, are hearing, as we should be, about the importance of actually reading the contracts and seeing what the actual provisions are. And I like your reminder that there is a distinction between civil law and common law, and we should be aware of that. Justin, let's turn to you. What issues are most likely to result in arbitration proceedings, and how should companies mitigate that risk?
Well, look, as I think we've touched on already, I think that most FM issues probably will be dealt with cooperatively. That seems to be the spirit of many of the FM issues that are cropping up now. But look, there are lots of different ways that the current situation might result in disputes, might result in arbitration proceedings. I mean, a couple that occur to me as perhaps particularly likely candidates are insolvency-related non-performance issues, and in the M&A context, where I think we've seen a number, and I think there will be further buyers seeking to escape deals, perhaps through non-fulfillment of conditions precedent, perhaps other issues. And also, I guess, there's the possibility here for claims for breaches of reps and warranties. And the key points that I'd emphasize really are ones that have already been made. Know your contract, check the key terms, FM, MAC, conditions precedent, termination clauses, and maintain good channels of communications with your counterparties, and also maintain good records. Back to you, Steve.
Very good, Justin. All good suggestions. Michael, give us a few takeaways from an Asian perspective.
Thanks, Steve. Look, just a few points here. I think the first is that both sellers and buyers need to look closely at diversification for future risk mitigation. Buyers in terms of sources of supply, and sellers in terms of sale destinations and perhaps even product diversification. The second is that I think that LNG and other long-term commodity buyers, and indeed their lawyers, will need to seriously consider modifying traditional FM clauses and some of the others that I mentioned earlier, like DQT, scheduling, cancellation, price reviews, and so on. It was already a buyer's market before COVID, and now I would not be at all surprised to see buyers press sellers for greater flexibility in these types of clauses when negotiating new contracts. In LNG, I'd probably also look for an acceleration of two trends we were seeing pre-COVID. The first is the trend of buyers acquiring an increasing proportion of their LNG requirements under spot arrangements, mainly pursuant to master sale and purchase agreements. Given the difficulties of modifying obligations under long-term contracts, not buying a cargo in the first place seems like a good way of further mitigating demand risks. So it may well be we'll see more spot contracting. And with that, I would also expect to see a push to LNG exchanges continue to increase. I also mentioned earlier that for buyers, it's arguable that claiming FM and DES contracts is easier than under FOB contracts. Pre-COVID, there was already a trend to more DES-style contracts, particularly in Asia, and I think we'll see more of that too. I'll leave it there. Thanks, Steve.
Thank you, Michael. I agree with all your comments. Sean, let's let you finish up this segment here, and what might you add on private equity?
Thanks, Steve. I think the only point I'd make around PE is that, as I said before, I think we're now entering a new phase following that immediate reaction to the crisis, and it'll be interesting to see how the next few months pan out at the PE house level. I personally think there will be a shift of focus back to looking both the exit side and the new deal opportunities. But there's no doubt at all there are still strong headwinds ahead, and it's going to be some time till we get back to the activity levels we had previously.
Sean, thank you. I agree with that, but we will get back, I believe, ultimately. This has been a real shock to the system, but we've had significant shocks before. Maybe not of the same nature or to the same extent, using my words from earlier, but this industry is amazing at its ability to come back after taking hits. So at this point, we'll now be taking questions. Please give us a few seconds to collect and review your questions, and we will be right back. And we're back. Thank you for your patience. So we do have a few questions here we'll hit quickly. Justin, let's go to you first. You earlier outlined the position on force majeure and material adverse change, but the question that has been asked is whether the legal principle of frustration is also going to apply.
Thanks, Steve. So under English law, frustration in principle might apply where you've got an event that occurs after the date of the contract, was not foreseen by the parties, is not within the control of, or wasn't caused by the parties, and importantly means it becomes impossible or illegal for one of the parties to perform the contract, or means that the performance has become radically different from what the parties had contemplated when they entered into the contract. And that collection of criteria means it's going to be a very high bar to actually prove that a contract has been frustrated. Amongst other things, the fact that there should be no foreseeability of the event means that if the event in principle might fall within an FM clause, means that in principle will mean that frustration is not going to be available. It's also a high bar in terms of actually proving that the frustrating event has made it impossible for a sufficient duration of time. So there's English law authority that the duration of the impossibility needs to be significant in terms of the overall duration of the contract. I think all of those points together means that frustration may be available, it may be something that people need to look at, but it's always going to be a high bar. And if you have an FM clause, that's the first place to look.
Okay, very good. Thank you, Justin. Let's take one more question here. Michael, I like this question that's come in because it's very forward-looking here. So in light of the impacts of COVID-19, do you think parties will approach force majeure and other long-term contract provisions differently in the future? And if so, how?
Yeah, thanks for that, Steve. Look, I think prior to COVID, we already had seen for some time that it was very much a buyer's market, particularly in LNG contracting. So we were seeing greater destination flexibility in terms of diversions. We were seeing DQT flexibility and cancellation rights coming into contracts and so forth. But really, FM clauses hadn't changed that much at all. They were still pretty much the traditional clauses that everybody was used to. But now, given the supply situation where it is post-COVID-19, I think the situation of it being a buyer's market is not only going to continue, but I think will probably become even more so. So in new contracts, I think that mitigation of these types of demand events are going to become a major focus. And I think buyers will be looking at all sorts of contract flex provisions to ensure they can maximize risk mitigation. But FM will be a particular focus. And I think the thing that will probably haunt buyers is that this time round, as I mentioned earlier, there are some difficulties associated with claiming FM around demand events. And so it's been either difficult to claim or it's impossible to claim, and that's notwithstanding that there has been demand destruction or inability to take due to storage constraints and inability to mitigate for the same reasons. So I think that this is going to need a lot of thought by both buyers and sellers, because I think buyers will want a solution. And I don't believe the same old clauses will be accepted by buyers in the same way in the past, particularly not in this region. And given that, again, in an LNG context, the largest buyers in the world are all in Asia: China, Japan, Korea, India increasingly. So I think that buyers will be looking at this and saying, right, if this happens again, how do we maximize our ability to weather this storm better than we did this time around? Thanks, Steve.
Yes, Michael, thank you very much. The ability to think outside the box is going to be really important as we go forward here, based on what's been done in the past, but you have to anticipate the future. So I think we'll leave it there. First, for those of you who are interested in the CLE credits, the CLE code for today, we had to work hard to find one that wouldn't confuse our American dating system here. AG0505. Once again, AG0505. And again, we want to thank everyone for joining us. It is difficult times, but just as that last question was looking to the future, let's all look to the future. And everyone, please stay well. And we'll say again, thank you very much.